a lot of employers are self-insured. So they might have access to that kind of information, especially if they're maybe considering promoting someone. You wouldn't want them to deny them a promotion because they're predisposed to some genetic, some disease that would show up in their genetics. So even if they're self-insured, they cannot look at this stuff, right?
Right. All employers are covered under GINA, whether they are self-insured or not. It makes no exceptions. It does lay out some specific exceptions in the employment context. There are no exceptions in the insurance context, but there are some in the employment context. Most of them are rather straightforward and matter of fact. An employer who, what the language of the statute says, inadvertently requests family history is accepted. These are the types of situations where an employer, we call them the water cooler exception, where an employer might ask an employee how they're doing. An employee might tell the employer, well, I'm not doing too well, I just got back from the doctor, et cetera, et cetera. Those types of situations where an employer didn't ask for genetic information but is being given it by an employee, that's an exception. There's exceptions when the employer is offering health services to employees, like a wellness program, though employees in that situation have a lot of control over whether or not they decide to give an employer that information. It's entirely under the employee's control. And there are some other minor exceptions as well. But there are no exceptions for discrimination in GINA, only for access to information under very limited circumstances.
So is there a private right of action?
Yes. In the employment section, there is a private right of action. It follows similar civil rights laws like the Americans with Disabilities Act or Title VII of the Civil Rights Act in terms of how that process unfolds. You have to go to the EEOC, the Equal Employment Opportunity Commission. They evaluate your case. They either decide to pursue it themselves, or they give you what is called a right to sue letter and allow you to go forward with a private right of action. The insurance section is slightly different. It is there are penalties, but it is governed. There is no private right of action. It's governed by the Department of Health and Human Services, which enforces that section.
That's unfortunate. That part, that there is no private right of action for that because, you can't always get these major federal agencies and to sue, and then they don't really sue on your behalf individually anyway. They only sue.
Well, it's a limitation, no question about it. But I think that all in all, GINA is as strong a law as we might have hoped for in most respects.
And you can go back, right, Jeremy?
You can go back. I mean, you can go back. Similarly with the Americans with Disabilities Act, which was relatively recently amended to make it even stronger. Certainly, that's always a possibility with GINA. I think that, as I said, I think GINA is a strong law, and my hope is that we can build on it for other federal legislation in areas, in other contexts other than employment and health insurance, where we can institute protections for individuals and consumers.
And you got your foot in the door. I've noticed that on being in part of helping to get legislation passed at the state and federal level. And you have to get your foot in the door first. And once you get your foot in the door, then you can try and bring in other aspects that once they understand genetic privacy, you can bring in more. So, that's kind
true.
of...
There was a lot of education on Capitol Hill that was required to pass GINA. And despite the fact that that members come and go, I think a lot of that education is there to stay. And GINA it represents a recognition by Congress that this is an area that requires regulation. And I think that, as you said, we can continue to build upon that as a foundation.
I was real interested in that campaign that you were successful at with the University of California, Berkeley. Their Bring Your Genes to Cal. The
Yes.
Tell us a little bit about that and what happened.
Sure. Well, in May of last year, just before summer began, and I don't think coincidentally, after the faculty and students, for the most part, had gone home for the year, the University of California, Berkeley announced that as part of their freshman orientation program for the fall of 2010, that they would be sending incoming freshmen a cotton swab with which to send in a DNA sample to be tested for 3 gene variants. And ostensibly, this was for a program that would teach about personalized medicine, and this was essentially a gimmick. It was a way of trying to get the students excited about school and about the topic for freshman orientation. The problem was that in their rush to and their zeal to push for this program, they really didn't give much thought or attention at all to many of the obvious, relatively obvious and necessary privacy concerns that were almost immediately raised. Everything from the privacy of the DNA samples themselves to the information that was going to be derived from those DNA samples, to a really atrocious consent form that offered incoming students really a complete lack of appreciation for what they were getting into by giving up their DNA samples. And then there were some relatively concerning conflicts of interest. Initially, there were some commercial genetic testing companies that were involved as part of the program in terms of there being a prize at the end for students, and then the professor who was leading this program on the behalf of the university had a lot of specific ties to commercial genetic testing companies, and a number of red flags were raised as to his interest in this program. So there was a lot of concern, and what I think really raised this to an all-new level was the complete dismissal by the university of all the concerns that were being raised. And these weren't just concerns that were being raised by advocates like myself. These were concerns that were coming from the faculty of Berkeley itself, that were being raised by the press all over the Bay Area, and the university really circled the wagons, and they met with the faculty, I think, once or twice, listened, and instituted none of the proposals that the faculty offered them. They made literally zero changes to the program aside from dropping the prize, which was such an obvious mistake from the get-go. They also refused to divulge where the funding for the program came from until the very end, and there's still some open questions as to why that was, whether they might have had funding from one source and then changed it as a result. They were very secretive about the funding for the program. In fact, my organization filed a number of were essentially under California Freedom of Information requests that were not followed by the university, and the university was actually slapped by for not following those requests. So the whole way the university handled the program and handled the criticism of the program, they really just seemed to delight in the attention they were getting, and didn't take the criticisms seriously. And so what happened was we mounted a campaign. We worked with many groups. We worked with the media. We worked with the California legislature. There was a bill introduced that was going to pull funding for programming in this area. There was a hearing in Sacramento about the Berkeley program, but concurrently we had been researching the program and had discovered that the university was going to be testing the samples in a way that was contrary to California regulations. And so we raised the issue with the California Department of Public Health. The California Department of Public Health looked into the program and agreed with us that it was that they were using unlicensed labs for these types of purposes. Any type in California and many other states, when you're testing DNA samples and then giving the information back to an individual, they have to be licensed. They were using university labs that weren't licensed, or they were planning on using university labs that weren't licensed. And so the Department of Public Health met with the university, and the university soon thereafter backtracked significantly in the program, and many of the original propositions for the program, personally identifiable information and such, were removed.